So he can change just because.
Well, yes, because he essentially could always have written you a ticket for whatever he thinks he can prove.
Sounds like a bullying tactic to me. And you're able to observe through a mirror that a person is going at a higher rate of speed as though they look faster or closer in a mirror than they originally are.
All right, gentlemen, we're here on this citation. It was issued on June 7th of this year on 116th Avenue there, Allegan Township. This is for a speeding citation on an actual 77 and a 55. However, this deputy used their discretion and wrote you a speeding ticket for going 1 to 5 over. You're here on this ticket for 1 to 5 over to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened. Or three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
Fight the ticket, please.
Okay. You understand that you do not have a ticket for going 20 miles over the speed limit. You have a ticket for going 1 to 5 miles over the speed limit. You understand that, right?
Yes, sir.
All right. So first thing I'm going to do is swear both parties in. Go ahead and raise your right hands. Swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yes. Yes, sir.
All right. Mr. McFilmley, it makes a lot more sense to me to start with the deputy. They have the burden to establish to me why you were issued a citation in the first place. But after that, you'll have an opportunity to either ask questions or testify on your own behalf. All right?
Okay.
And with that, deputy, you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation.
Yeah, Your Honor, I have a quick question first. Since we're here to contest the original stop and speed, I'd be curious if we could amend the ticket to the 21 to 25 over.
Yeah. So, Mr. McFilmley, let me spell this out for you. All right. This officer, I'm assuming, is prepared to testify that you were traveling well above the ticket that you have. He wrote you a ticket on the road, about the wimpiest speeding ticket he could write, 1 to 5 over, assuming that you would see that for the break that it was. But you're here saying you wish to contest the ticket. So what he would like to do is amend your ticket to the speed he thinks he could actually prove in front of me. Do you understand that?
Yes.
Do you have an objection to that?
Not per se.
All right. And so if you had a ticket here that was, will really be 15 to 20 over, you would still wish to contest that ticket?
No. I mean, he's already wrote the ticket for 1 to 5 over. I don't see how this could be changed.
Well, that's what I'm telling you is I'm putting you on notice right now. If you have a ticket that's for 15 to 20 over, would you still wish to contest that, or would you somehow wish to admit that?
But he wrote the ticket for only 5 over.
Sure, and it's his discretion. He could write you a ticket for anything he wants. He may not be able to prove it, but essentially you're not willing to accept the ticket for 1 to 5 over. You would like to contest that ticket.
Yes.
You understand, if I found that proofs were that you were traveling even faster than that, I can amend that ticket up. It would be more fine, more points. You understand that?
So he can change just because?
Well, yes, because he essentially could always have written you a ticket for whatever he thinks he can prove.
And he wrote 1 to 5.
Yes, but I would certainly allow him to amend that up. And then if he amends it up, and then you're going to have a hearing on that ticket. So I'm giving you an opportunity to sort of see the forks in front of you. Is that still your contention, that if I allowed him to amend that ticket, you would like to have your hearing today?
Sounds like a bullying tactic to me.
Well, that's your opinion. Is that what
With
you
that
wish to
smart,
do?
yeah.
All right. I will hear proofs and then we'll decide on what amendment I will allow. Deputy, if you wish to proceed, go ahead.
Yes, sir. So first off, I'd like to say that I am certified in speed measurement within the state of Michigan. My radar unit is calibrated at the beginning and end of my shift, utilizing my independently calibrated speedometer within my patrol vehicle on 6/7/2024 at approximately 09:23 hours while on patrol, running stationary radar on 116th Avenue near 29th Street in Allegan Township, Allegan County, state of Michigan. I observed the defendant's vehicle, a black Kia passenger car, traveling at a high rate of speed. Upon activating my radar, and detected the vehicle traveling 77 in a 55-mile-per-hour zone. The defendant's vehicle was the only vehicle within the operational beam of my radar. The audio tone produced matched the readout provided, and there was no RFI present, as my radar unit would not provide a readout if such was present. A traffic stop was conducted where the defendant pulled over prior to me activating my emergency lights. The defendant then advised that he was aware that he was above the posted speed limit of 55 miles an hour and was headed to a job interview. The defendant was then issued citation number SD 28818 for speed 1 to 5 over, which is down from the 77 in a 55-mile-per-hour zone that the radar originally gave a readout for.
All right. Then, Mr. McPhilmy, this is your opportunity to ask questions or testify on your own behalf.
Okay. I'd like to ask the officer if he recalls the way of which he was facing, either north, east, south, or west at that time.
I would consider that a direct question. I'm not the intermediary here, so that's properly formed question.
Okay. So I was facing eastbound on the south side of 116th Avenue.
Okay. As facing eastbound on south side of that 116th, I also was traveling eastbound. So therefore, can you recall the position of my vehicle when you caught radar to your vehicle?
It was west of me, traveling eastbound, 116th Avenue, going down the road.
And if you were looking east,
okay,
your car was
Mr.
facing
McPhilmy,
east.
I'm going to clear this up for you because I think I know what you're getting at. Deputy, can you please explain how many different radar options you have with your vehicle?
I have 4 radar options inside my patrol vehicle, 2 that go forward and 2 that go to the rear.
And you have the filed paperwork to prove that these are calibrated, not just by hearsay of each and every shift?
Yes, sir. It's documented.
I will also inform you, sir, hearsay is allowed at informal hearings. Hearsay is a criminal standard. You're confusing.
Okay.
I mean, to be clear, because I want this to be fair to you, you're right that hearsay is a thing, right? Hearsay is an out-of-court statement asserted for the truth of the matter asserted. It is not allowed in a criminal proceeding where your possible punishment is incarceration. This is a civil infraction. It is below or beneath that standard. Hearsay is allowed.
Okay.
Just to clear that up for you. So, but go ahead.
So we have on recording record of with file proof of his calibration of his units.
Yep, there's the entire folder of documentations at the sheriff's office of each and every radar and patrol vehicle that is filed away.
And that's not something you can prove at this time?
don't have to produce that at this time.
I would certainly be against that.
Duly noted, sir. I will inform you for the record, though, for purposes of an informal hearing, it certainly is not necessary. You could file a motion at formal hearing for that to be produced as evidence, but you would have done that ahead of time.
Interesting. So as back to the east, facing east, your radar just runs immediately. And do you have video proof because there were other vehicles at that time?
No, my radar is activated upon when I activate it.
Okay, so me coming up behind you as if you were facing east, looking ahead at the traffic ahead of you, you were able to notice me and what possibly might be a mirror in which objects appear closer than than they originally do.
Yes, I observed you in my mirror. I observe many vehicles running radar 12 hours a day for the last 10 years.
And you're able to observe through a mirror that a person is going at a higher rate of speed as though they look faster or closer in a mirror than they originally are.
Oh, you are so dumb. You are really dumb. For real.
That is part of my job to do so.
So your eyes can calibrate through a mirror of speed to be able to switch your radar on?
After observing traffic for 10 years as a law enforcement officer, yeah, typically you can tell when a vehicle is traveling faster than the speed limit in that area, especially when it's 22 miles an hour over that said speed limit.
I don't believe that could be plausible through a mirror.
Okay, sir, that's not a question. You're now testifying. That's okay. You can make your arguments, but only after you present your evidence. Arguments are not evidence. So this is either for direct questions to him, or
so
you can
arguments
go right into
are
a
not
narrative where you testify for yourself, but argument is not evidence.
arguments not evidence, but hearsay can be used.
Yes, sir, because hearsay is a form of evidence. It's not a form of argument. Let me be clear. Here are your options right now, because we got to keep moving. You can either ask him questions, right? You can't just start arguing with him. Or you can testify on your own behalf of what you think the evidence is of that day. But what you're making is argument.
I am also providing evidence of how an officer could possibly acknowledge by a vehicle that is behind him when he is facing away from that vehicle at incoming traffic, when there in fact was other traffic, and make a reasonable suspicion.
Sir. You're arguing that. You have not testified that yet. What you would testify is, then just tell me your version of events, what you think happened that day and why you don't think you should be in trouble for speeding. You can do that now. But you doing it in the form of as question and answer to the officer is not the appropriate way to do that. You can give a narrative testimony of your own point of view of what happened that day. I would invite you to do so. Because right now the evidence presented is simply the evidence from the officer that you were in fact speeding. So now it'd be your opportunity to offer in evidence, your own testimony of why you don't think you were speeding.
The evidence is just what he's saying, though. There's no video, there's not anything saying
sir, you're arguing. If you wish to argue, we can wrap this up and I'll give you a ruling, but you're arguing. I understand what his testimony is. His testimony is evidence.
I'm saying that what he is showing, he is not having he's not showing the files of his calibrations in court that he says are at the sheriff's office. that you say doesn't
Sir,
need to be presented,
I'm
but
gonna
how
tell
can you
you one
not
more
present that in a
time. What you
traffic
are
law?
doing is arguing the evidence. What I have to do is I have to make a determination based upon the evidence presented. I have more than enough evidence presented by the plaintiff at this point, by the officer. Would you like to present any evidence for yourself of why you should not be found responsible on your speeding citation? You would do that now if you wish to.
My evidence is the video proof of his video recording.
Okay, sir, I'm going to explain this to you one time. They do not have to provide video. They've almost never provided video. If anything, video might kick on once their lights are turned on in pursuit of you. They would never have video sitting stationary watching cars go by. That's not a thing. It's never been a thing. And most of the cars, it's my understanding, don't even produce video even when the lights are turned on. But you're way before that part of the stop, and you're arguing something. What I'm saying is, if you wish to testify that you weren't speeding, you should do that now.
I was not.
Okay.
And I'd like him to prove that. Proving what
Okay.
all he's
All
doing
right.
is saying.
So here's my
saying
ruling.
that I was.
He has more than proved you were speeding. He has visually observed you speeding. Listen to me now. I gave you a chance for argument. You made none, essentially. And so here is my ruling. The evidence against you is that an officer has been doing this for 10 years, visually observed you moving at a high rate of speed. Now, you're right. We don't let officers say, oh, I think that car is going X miles an hour. They probably could with a great deal of accuracy, but we don't let them do that solely. So what we have is the officer with 10 years experience saying, I'm watching you and you're moving at a high rate of speed. So then what he does is turn on his rear-facing radar that hits you, and his testimony is that you were in the range of that radar and he had no unobstructed obstructions to that view, that it audibly toned out, consistent with the number he was seeing, the 77, in a posted 55. If the audio tone was different, he'd know something was wrong. He also testified that that's his separately calibrated speedometer, or that radar is calibrated against his separately calibrated speedometer. Now, I'll go into this a little more so that you can feel like you're not getting railroaded here, but these aren't questions you brought up. Officer, when do you run that test on your radar to make sure it's in proper working order for the day?
At the beginning and end of my shift.
At the beginning of your shift, if it went through its self-diagnosis and determined that it wasn't working, what would you do about writing speeding tickets that day?
I would instantly turn it back off and get it serviced, and there would be no radar enforcement that day.
If it was working in the beginning of your shift and you wrote speeding tickets all day, they said you ran it you run it at the end of your shift too. At the end of the shift, if it wasn't working, what would you do about the speeding tickets you wrote that day?
I would void all speeding tickets that were issued said day.
All right. So that's the accumulated evidence against you that you were speeding this day, sir. At this point in time, I have no other evidence that you weren't speeding. You simply said you weren't speeding. You didn't give me a speed you did think you were going. You didn't give me anything else to go on other than argument.
And I'm asking, he doesn't have to show proof of that exact day of those calibrations? No, of whether they were working or not working? Let's see, how does that work? We are in court. He should be able to prove that.
Yes,
because the only other thing, he did not. There's nothing that shows. He just said he did.
You can argue that all day long, but his testimony that it is in fact those records. So
we can just go by what somebody said. Enough.
Yes, sir. If you had some reason to believe that the officer is lying or that this machine is not properly calibrated, that would be for you to dig into. But you can't, you're just sort of throwing that out there as a red herring. And the only person who's qualified here to tell us that it is in fact there and does exist has told us it is there and exists. So for purposes of informal hearing, I would certainly find you responsible on this. I am going to find you. Do you wish to tell me how fast you were going? Well, first of all, what did you think you got pulled over for?
For a slight increase in speed.
All right, so how fast is it that you think you were going? You have a ticket for going 1 to 5 over. You don't agree with that. You're here to fight it. So how fast do you think you were going?
59.
Okay, but you realize that if you were going 59 and a 55, that's how many miles over? 4 miles over, right?
Yep.
And you have a ticket for going 1 mile over, 2 miles over, 3 miles over, 4 miles over, or 5 miles over. But you said, I don't agree with that. I didn't do that. But
The ticket is for 5 over.
1 to 5 over, sir. I don't know how many times I can repeat that. I don't know how many times you've looked at your ticket. You do not have a ticket for going 5 miles over. You have a ticket for going 1 to 5 miles over. And I explained that to you very clearly. So I am going to find you responsible on this citation as it's written. If you wish to appeal that ruling, you can go to formal hearing. To go to formal hearing, you must do 2 things. You must ask for that within 7 days of today's date, and you must come in and post a cash bond in the same amount of the fine to guarantee your appearance. If you go to formal hearing, this officer can amend this to a 22-mile over ticket, and that is the ticket you will face instead of the ticket I just found you responsible on. Do you understand your options on appeal?
Yep.
I want to be clear because it sounds like maybe you want to appeal. You understand the 2 things you have to do?
Yep.
He's a blowout.
All right. Then we are all set for what we need to do here today. I'm going to go ahead and release parties.